Good morning, good afternoon, good evening, wherever you may be in the world. Welcome to our last day of the ARAC conference. It's funny now when I call it the Asia Regional Anti-Trafficking Conference, because of course that is what it is. But since we converted to going online last year due to COVID, this has kind of morphed into what has become a global conference, really. So we've got people joining from all over the world. So, and we're just saying, you know, when we hope to go back into person next year in Bangkok, we're actually still planning on having a hybrid so that we can make the most of both. So anyway, this morning's session, I am more than delighted to introduce Archana, who is both a colleague of, we don't even talk about how many years, Archana, and friend, and just seriously badass lawyer and advocate for the most vulnerable populations, not just in Asia, but her influence spans the world. And so without further ado, I'm going to hand over to Archana, who is going to present for us this morning. And then we are going to have some time for Q&A. So please put questions in the chat or in the Hoover app. And we will come around to those after Archana's finished. So thank you, Archana, for joining us from Hong Kong, and over to you.
Thank you. Thanks, Helen. And thanks very much to the ARAC team for having me this afternoon from Hong Kong. And just to say very briefly that many of you, or some of you might know me from my Liberty Shared days, where I was Asia Region Director and Head of Legal for Liberty Shared. And I recently left. So last October, I left to set up the Remedy project, hence the bright burgundy color that you can see on the screen and the yellow. And the Remedy project is a social enterprise that is registered in Hong Kong. We have a small team in Hong Kong, a small team in Cambodia, and we're very much focused on building remedial solutions for global supply chains. So essentially looking at different ways in which worker advocacy, corporate governance issues, and various other stakeholder needs and concerns can be brought around different frameworks in order to hit the needs and agendas of as many stakeholders as possible. The idea being to take a very systematic approach towards not just the provision of remedy to some of the most vulnerable in global supply chains, but also to look at the underlying causes and the underlying corporate governance systems that need to be reformed in order for the change to be sustainable. And amongst other things that we're doing a lot of advisory work for the private sector, for some government actors, for some of the larger INGOs, around victim protection, around some prosecution issues and capacity building issues. So it's a real pleasure to be here. And what you'll hear from me over the next presentation really is a bird's eye view from my desk of the issues that we have been dealing with over the last year. And I guess I'd like to start with a few overarching comments. And the first one is this. I think whether you look at it from a labor exploitation perspective or a sex exploitation perspective, or from any angle of the spectrum of exploitation, one thing is abundantly clear, that we are still faltering when it comes to maintaining and upholding a rights-based approach. We are still very much coupled in our perception of people's rights with the outcomes of the criminal justice process. So although technically on paper, victim support is not conditional on collaboration with law enforcement, in reality and in practice, it's a very different story. So essentially what happens is a system that is designed to support and protect also becomes a system that exercises duress and coercion on an individual. And it is absolutely essential that as we maintain our efforts, we grow our efforts, we collaborate, and we coalesce together in our efforts to combat exploitation, that we are really mindful of pushing the rights-based approach forward. And this means looking at criminal justice as an entity on its own, with its own outcomes, but looking at individuals whose rights have been violated as individuals of their own right, entitled to those rights and to the enforcement and knowledge and awareness of those rights. The second comment I'd like to make is, if one doesn't decouple the rights-based approach from the sort of criminal justice outcomes approach, then one risks skewing processes like identification. So it's only interesting to give a positive identification if this is a good case to prosecute. Otherwise, there's not much point. If you have somebody who's not collaborative, this is clearly going nowhere, even if it could potentially have some merits, then what's the point? So processes of identification, again, necessitate this strong rights-based approach very independently of any criminal justice outcome. And this involves taking a holistic approach towards it, in building in reflection and recovery periods, not coercing individuals, provide provision of information and independent support as soon as possible, as early as possible in the system, but also a real sort of sharing of knowledge and understanding between different stakeholders, state and non-state, around what are these identification features and what is the process. Because transparency and accountability in the identification process is so important. And of course, if the identification is wrong, then you have issues like criminalization, deprivation from essential support, et cetera, et cetera. The third thing I wanted to highlight was this inevitable meshing of individual coercion and systemic coercion. Our laws are very well equipped to deal with instances of individual coercion. So the instances where an individual is coerced in a particular manner, given their particular circumstances. But when we take this in a different context and we start to think about COVID, the impact of COVID, the systemic coercion of migrant workers in COVID, then you start to see the systems, the legal frameworks let you down. They're not equipped, they're not built, and they're not interpreted to deal with these issues. And that has been, we suspected it all along. We have seen it in our courts, we've seen it in our judgments, but COVID-19 really brought this to the forefront. And most systems came down to their knees because of this. So I guess, the last overarching comment I'd like to make is about the spectrum of exploitation. I think we gave exploitation the face of human trafficking for the longest of times. And we really just associated exploitation with trafficking. That was the focus of donor money. It was the focus of a lot of the anti-trafficking movement, etc. But I think there's been a real resurgence and emergence of forced labor as an issue to contend with. And it has really highlighted the difficulties in separating or finding the dividing points between the different offenses along the spectrum of exploitation. And I think that's one thing that continues to really challenge legal systems, legal frameworks, law enforcement officials, labor inspectors, and also prosecutors and judges. And sadly, those who fall through the cracks are the most vulnerable. So with these comments in mind, I'd like to begin my presentation with looking at the issue of COVID-19 and wage theft, which has been a very big issue, and also with CBP bans, etc., and their impact on remediation in particular. I'd then like to take a look at some opportunities that have been put forward by strategic litigation efforts in Southeast Asia, but also across the globe, and opportunities for us to learn from and perhaps apply to our own work, to really think about forced labor and human trafficking, and what that looks like in practice. And finally, to just do a quick roundup on business and human rights and the emerging environmental, social, and governance movement. And the idea really is to leave you guys with an idea of some opportunities that are there and some interesting work that's being done in the region. I think we rarely take a moment to stop and celebrate some of the breakthroughs and the successes that are happening and that we should be learning from. So the impact of COVID-19, I mean, there's been a lot written and documented around the brunt of the wage termination and non-payment, job termination and non-payment of wages of garment workers, for example, across Asia. There's been a lot of press around the fact that brands refused to pay or cancel orders caused a lot of suppliers to shut down, and these losses were actually passed on to workers. And you know, some of the price cuts demanded went up to 12% in comparison to 2019. This not only led to already high risk living and working conditions being really pushed to the brink. Millions of garment workers, and not just garment workers, but you know, workers in construction, workers in many other sectors, were furloughed or fired. Some people were repatriated, others sat at airports for days with no compensation, severance pay, and with very little access to remedy or justice or any kind of mechanism in order to file claims before they were repatriated or before they left the destination country. A lot of dismissals were used to target workers who were unionized and factories where there were active unions. And, you know, just to give you an idea of the value of wage losses, Asian garment workers alone are estimated to have been deprived of 12 billion in wages and severance pay, and sort of around 1.6 million job losses in the process. It's a staggering number if one thinks about the consequences on not just the lives of the workers, but their communities and their families as well. This is huge. Now, there's been some interesting local legal actions filed against fashion brands, garment manufacturers, both in India and Sri Lanka. The matter I'm referring to in particular is being run by the Asia Floor Wage Alliance, which is a coalition of organizations very active in the region. And they've developed a very interesting legal strategy, which is basically premised on holding both the brands and the manufacturers jointly liable under national law for either non-payment of wages or partial payment of wages. And the idea is that because brands have economic control over the supplier, and they are unable to pay workers as a direct result of brand sourcing practices, and therefore they have control over the workers' employment too. Now, if successful, this strategy will really improve corporate accountability in Asian countries and be a very, very interesting action to replicate across jurisdictions where it is possible to do so. It's very interesting because it also comes at a time where a lot of the large consumer markets, such as the EU, the US, are being regulated with new due diligence and modern slavery laws. But also, you know, it's interesting because this is a movement that has taken rise in Asia using existing national laws. And it's very interesting because there's a lot of advocacy around we need new laws, but the ones we have are not used so much. So this is a very interesting occasion to see this work. And also there is a big role for brands to play, particularly when, you know, it comes to stepping in to compensate workers where local manufacturers fail to do so. We hear increasingly that local manufacturers are closing shop and that workers are often left out of pocket entirely for months and months on end with no possibility of recourse. But increasingly, we're hearing of news of, you know, brands stepping in and helping to shoulder some of the wages that are outstanding or any of the benefits that are outstanding to the workers. For example, there is example of Tesco, which paid $24,274 US to some workers and gave another 1.1 million baht to the MAP Foundation to support migrant workers in Mesot, when one of the companies that was meant to be paying its workers defaulted. And again, similarly, there are accounts of Starbucks partners, NBC Universal, Disney, etc., also having to step in because local manufacturers default. the importance of the brand and the buyer engagement, cannot be underestimated. For example, if you look at the cases studied by the Business and Human Rights Resource Center, they found that unionized garment workers have been really targeted for dismissal in factories across a number of countries: Myanmar, Cambodia, Bangladesh, and India. And of the 9 cases of union busting, 6 remain unresolved. What is interesting is that the 2 cases resolved in line with union demands were the only 2 instances where brands were directly supported in engagement with the union and the factory. It just goes to show that when brands are involved with the union president and the factory management and apply pressure and leverage, that there is a possibility of bringing around solutions. And there is a case to argue that each of these parties has their own degree of responsibility towards fixing, this system that is broken, not just in one place, but in several places. Now, there's been a lot of news around the US CBP import bans. This has crossed several jurisdictions, and this has crossed several sectors. And if I take in particular the most recent ones against Malaysian manufacturers, the issue of the WROs against the glove manufacturers and palm oil companies in Malaysia has been really interesting. Interesting from a number of perspectives. One, these bans lead to fairly negative financial and reputational impact for the companies. Companies are most aggrieved where they experience legal, financial, or reputational risk. And just to give you an example, the ban affected Top Glove's sale significantly. Top Glove was also ousted from the ESG index, which is the Environmental, Social, and Governance Index, which is run by the Malaysian Stock Exchange. It was also scheduled to list in Hong Kong, and that has also been delayed until resolution of all the issues that are plaguing it, particularly around labor. Again, another example, Sime Darby's shares fell by 3.5% after news of the ban. And then again, 1% after news that its Human Rights Commission experts resigned. The interesting thing about this is that the advocacy around sort of, shareholder activism, investor activism, investors speaking up and saying, we want to see improved labor and environmental and governance practices within these companies in order for us to invest in these companies is really interesting and an opportunity for advocacy and to sort of, push for that extra mile. BlackRock, for example, was very vocal in saying that they didn't want Top Glove's directors to be re-elected and that they didn't deserve to be re-elected given Top Glove's track record. And essentially, this presents an interesting opportunity also for remediation. The unfortunate thing is that the definition of sufficient remedial steps that need to be taken by companies is still very woolly and has looked different depending on the case to hand, the actual WRO, the degree of information out in the public domain, and the company's response. And therefore, there has been a very big focus on immediate repayment of recruitment fees, improvement of worker accommodations. But there isn't sufficient clarity at this point in time over what is the bar and what is the level that needs to be achieved in terms of remediation and in terms of addressing the underlying issues, so that we're not just addressing it for the short-term future, but we're addressing it on a more long-term and sustainable basis. And much more clarity on that front would be very welcome. And it's interesting as well to note that, several other jurisdictions are also contemplating import bans of this nature. So members of the European Parliament are actually looking at options to introduce a similar human rights-based import ban. Australian MPs and the president of the Australian Council of Trade Unions have also urged their government to empower border authorities to detain shipments that are tainted by exploitation. So, if And as and when all of these different sort of pieces of regulation fall into place and come together, it'll be interesting to see the kind of tightening of the net over the supply chains that are based in our part of the world, and the impact that this has on driving up standards and driving up remediation as well. So very closely linked to this idea of, having an ecosystem where there needs to be, some fundamental shifts in approaches, in interaction of stakeholders, and in a sanctions-based approach. The next sort of, thread of accountability, in a sense, really is strategic litigation. And what is really interesting is we talk a lot about disclosure regimes and the need to disclose under various, modern slavery regimes, etc. The truth is that disclosure is disclosure. Disclosure is not accountability. And therefore, for the purposes of accountability, strategic litigation remains a very, very important aspect. And I wanted to start by talking to you about a case relating to the environmental movement and land grabs in particular, because I think this presents a really interesting case study that there is much for us as part of the anti-trafficking movement to really learn about. This related to a land concession that was granted by the Cambodian government to the Cambodian subsidiary of a Thai sugar company. The villagers were forced to give up their land for the concession, and Cambodian NGOs filed a complaint with the National Human Rights Commission in Thailand, which actually found that the company was responsible for human rights violation. This was then followed by a class action suit filed in Thailand for losses incurred by the company's actions. The court of first instance denied this, but the appellate court overturned the decision, and now the class action is proceeding. Again, as I said earlier, this was brought to life by a very strong community of lawyers and NGOs who have shown the ability to work across the region and to be able to promote corporate accountability across Asia and while based in Asia. I think there is, they faced very similar challenges to those in the counter-trafficking movement, namely in terms of the asymmetry of power that often exists between companies and plaintiffs. They also faced, a lot of the same issues around criminal defamation. They also faced issues around intimidation, threats, etc. But yet, this is an example that it can be done. And it's an example of a successful cross-border action within the region, which is something to be celebrated and really to be learned from as well. The next case I want to talk about is the Maran case, and this case is very interesting because it involves the sad demise of a man named Mohammed, who worked on a shipyard in Bangladesh, and he died while falling to his death demolishing an oil tanker. And the oil tanker was sold to the demolition yard by a company named Maran UK Limited. And what was interesting about this case was that the court said that even where the damage is caused by the negligence of a third party, for example, in this case, the shipyard owner in Bangladesh, the UK company could still be held liable because it knew that the ship would be demolished in such a shipyard where the working conditions were widely known to be unsafe. And therefore, there was a relationship of proximity that could be established between the victim and the company. And it's a very interesting use of the relationship of proximity, even though the UK company was in the UK and there was, so to speak, so much distance between the UK company and the individual who passed away so tragically in Bangladesh. It's a very interesting case and one that also presents possibilities for other sectors and other geographies within the UK, especially where there is a nexus with a UK company. The next case I want to mention is the case of Vedanta. And, in case you're wondering why I'm talking through these case studies where there are such, international companies, We also, in our part of the world, deal with a lot of the companies that are either subsidiaries of companies that are based in Europe, in the US, or wherever else, or we are dealing with, supply chains that are intimately connected with buyers who are based in those locations. And therefore, whenever issues of corporate accountability are assessed, it's really important to look at where the potential connections are. And these cases heard in different countries give you an idea of what the thinking is in that country around, openness to hearing cases coming from different jurisdictions. So the case of Vedanta, again, was a very interesting one. And the UK Supreme Court found here that a UK incorporated parent company could be liable for the acts or omissions of its majority-owned subsidiary. In this case, the majority-owned subsidiary was a Zambian subsidiary running copper mines in Zambia. And as long as it could be proven that the parent company was sufficiently intervening in the conduct of the subsidiary's operations. Now, if you wonder what that might look like and what constitutes sufficient intervention in the operations of a subsidiary, an example would be a sustainability report that could basically suggest that the parent company is not only speaking about its own sustainability efforts, but also about the sustainability efforts of its subsidiary, or where it has not only outlined its own environmental control standards, but it has also said it has been training its subsidiaries on monitoring, enforcing, etc., and that all could be imputed to interventions by the company in its subsidiary's actions. And of course, the case of Nevson, which is the Canadian case brought by a number of Eritrean men who were conscripted through Eritrea's military and who worked in the Bisha mine located in Eritrea. And this, that was connected to the Canadian company Nevson Resources Limited. And it's the first time that courts found that a corporation could be held in civil liability for breaches of customary international law. And by that, I mean prohibitions against forced labor, slavery, cruel and inhuman degrading treatment, and crimes against humanity. And what these cases really show is that there is a shift in the tide, and it's becoming really interesting how a number of courts across different countries in the world are becoming a lot more amenable to hearing cases relating to harms that have occurred in a faraway land, but somehow connected to the home country. The success has not been replicated in the US under the Alien Tort Statute, which unfortunately, in a recent case involving Nestle, actually said that there is more domestic conduct than general corporate activity common to most corporations that is required. And there hadn't been enough proved that there was domestic conduct, which actually resulted in the exploitation of children in Côte d'Ivoire. And we've seen some really interesting cases brought under consumer protection laws to pressure brands to improve their labor practices. However, none of these have been successful to date, and the courts have actually affirmed that advertisers don't have a duty to disclose upstream labor abuses in the product supply chain. There is an interesting case ongoing at the moment where Coca-Cola is being sued for alleged greenwashing statements. So they suggest that they are a sustainable and environmentally friendly company. And the allegation is they continue to produce plastic on a large scale, therefore they cannot be calling themselves this. What's interesting about this is that it really goes to show that there is a clear need to back up any statements that are made by the company, whether as part of its ESG disclosure or whether as part of its modern slavery disclosure, or even in its sustainability statement, to really show that there is concrete action taking place and there are measures being taken to address exploitation in their supply chains. We recently did an interesting study for the Freedom Fund, which aimed at looking at, what could be done to strengthen the ecosystem of strategic litigation in the space of corporate accountability in Southeast Asia. And there were some clear issues that emerged. Aside from the usual asymmetry of power, the criminal defamation issues, some of the salient issues were actually around resources. Supply chain research is very expensive. Oftentimes, the NGOs or lawyers who are working on these cases don't have the resources required in order to be able to gather evidence and to do further digging in order to build a case against a company. There is also still a lack of trust and not enough engagement between NGOs on the ground in our part of the world and NGOs working in the global north. We'd like to see a lot more cooperation and a lot more confidence in the formation of these relationships so that we can start to really work on case pipelines, particularly where these cases have a jurisdictional hook. And I guess, a final observation on this point is that it does require a shifting of the mindset that we are not always going after individual perpetrators, and that perpetrators come in shape and form of corporates as well. And it's really important that we recalibrate our actions and rethink evidence gathering and, the sort of resources that are required when you're dealing with a case of this nature. Most of our legal frameworks in the region give us the ability to pursue corporates. We're not using them enough, and we need to be engaging with them a lot more. Now, cross-cutting all of the issues that I've talked about, and going back to a comment I made earlier around the sort of the anti-exploitation movement really being the anti-trafficking movement, and this difficulty with really teasing out what is forced labor versus human trafficking, etc. I mean, recently in Southeast Asia, there have been some attempts to define forced labor. For example, Thailand passed a law in 2019 which defines forced labor and has very specific penalties for forced labor. Victims of forced labor are also entitled to the same protections as victims of human trafficking. And but the interesting thing is no cases have yet been prosecuted under this new law. And there is a real sense amongst not just prosecutors, but also those working on the ground, that there is a real lack of engagement and understanding with what the law means and how it needs to be interpreted. In particular, when the perception of exploitation and the understanding of perception of trafficking over the years has actually, of exploitation over the years has been dominated by trafficking. And because with forced labor, there's the added complication of the distinction between singular labor law violations and, composite features that would form forced labor. This has added to a lot of the difficulties. In practice, what does this mean? In practice, this means that victims of forced labor are not being identified correctly. As a result, they're not being supported correctly, and they're often criminalized for offenses that are committed as a direct result of their exploitation. And it also means that, there are very few investigations and there's a lot of impunity in this area because there is a strong awareness amongst, perpetrators that they are above and beyond any form of accountability. And the consequences for individuals who are victims of forced labor are very real. And similarly, in Malaysia, there is another piece of law which, looks at forced labor. However, this is a piece of law that exists in the penal code. The penalty is fairly soft. It's not a provision that is used on a regular basis. There are currently revisions going through Parliament or tabled to be heard by Parliament in relation to the Anti-Trafficking Act and also in relation to a definition of forced labor. However, in the cold light of day, and as a practitioner, it is very common to see forced labor cases being shoehorned through the system as human trafficking cases. Because the threshold of proving human trafficking is already so high, the forced labor cases almost inevitably never make the grade and therefore fail. By virtue of failing, individuals are not just criminalized, but they also lose any opportunity to access support and remedy. So, it is essential that where there are laws relating to forced labor and there are definitions relating to forced labor, that these are interpreted bearing in mind the contemporary situation on the ground, bearing in mind the fact that coercion is not just individual, it is also systemic, and bearing in mind that, forced labor is a very common feature of business today and therefore must be addressed in a very dynamic way as opposed to a reactive way. I wanted to also talk a little bit about business and human rights, in particular about some of the changes that are happening globally. Very often one wonders, if the laws change in Europe, what does that really mean, or how does that translate in terms of impact for us working in Asia? It's very interesting because a lot of one of the largest consumers globally is the EU. And as the EU buyers and consumers get regulated fairly tightly in relation to what they are doing in relation to impacts on human rights and the environment within their businesses, their own operations, and their relationships, it becomes a very interesting picture. Because for one, as buyers, they don't want to take liability or assume liability that may happen further along in the supply chain. So the imperative really is to use leverage in order to drive up the standards within the supply chains that are connected with these buyers. So for example, the proposed law at the moment has certain provisions, one of which is to have a grievance mechanism to enable stakeholders to voice any human rights, environmental, or governance impacts in line with the UN guiding principle. Businesses are required to provide for remediation. I mean, we are yet to know whether these proposals are going to be mirrored in the final piece of law or that they will be significantly watered down. The point is that, by having these mechanisms that are not just about transparency, but that are also about accountability for grievances and for, showing concrete measures that are being put in place to address identification of risk and management of risk, it will have a knock-on effect on supply chains in our part of the world, because our supply chains will have to raise their standards in order to identify and manage liability. And there will be a great deal of pressure from the buyers who are regulated by these laws to see an improvement in standards. And at this point, I'd also like to say that these buyers also have a responsibility to invest in the improvement of standards across their business relationships and their own operations too. We've seen, for example, a new law passed in Germany in June 2021, which not only imposes a duty of care for managing and addressing human rights and environmental risks, but also there are significant administrative fines for non-compliance. Companies would be required to submit plans to remedy compliance deficiencies, but the possibility of redress is fairly limited. So only NGOs and unions could file a lawsuit against companies in Germany courts on behalf of victims. And these must be brought under existing laws. The devoir de vigilance in France also presents a very interesting opportunity, and there have been some fantastic NGOs working out of France who've really been using this duty of vigilance to hold corporates accountable for lack of disclosure and lack of accountability as well. So, a lot of these corporates have operations in Asia and in Southeast Asia, and it becomes a really interesting opportunity to really join forces with organizations that are working in these European markets in order to see how we can bring these cases and how we can bring this pressure to bear to raise the standards across the supply chain relationship. And of course, there's been the modern slavery reporting requirements. We now know that the UK has tabled amendments to its bill in order to give it more teeth. It was initially very soft in terms of its requirements, and some of the teeth actually include suggestions for imprisonment of directors for false or incomplete statements. I think it remains to be seen whether these will actually ever pass. Canada, as you can see, is also considering a Modern Slavery Act, which would prohibit the importation of goods manufactured or produced by forced labor. And again, mandatory reporting requirements. And you'll see the growing trend really is that where you have mandatory reporting requirements, there also has to be a stick with it for non-compliance. There have to be consequences. So if there are violations, there must be the possibility of an individual whose rights have been violated to bring an action in the relevant country against the parent company or against the buyer for what has actually happened. And these, again, present very interesting opportunities for the strategic litigation ecosystem in Southeast Asia and Asia as well. And these are legal instruments that can be used to hold subsidiaries of EU domiciled companies, for example, that are operating in Asia Pacific accountable. There's no reason why this would not apply to financial institutions, for example, where financial institutions are banking and knowingly banking clients who have fallen foul of a number of human rights standards and laws. We are hearing more and more of pressure being built around, not just the perpetrators themselves, but also the networks that allow perpetrators to flourish, and that includes financial institutions. The example of all of these pieces of laws emerging are really an extra tool in the toolkit for legal practitioners who are seeking remedies for workers in supply chains. And, they are a real complement to the existence of national pathways to remedy. So, for example, we talked earlier about the Asia Floor Wage Alliance campaign and case, which is a very interesting example of an Asian-led action. We also looked at the Mitpol case, the sugar case, which was a very interesting example of a cross-border action between Cambodia and Thailand. And these new pieces of legislation present very interesting opportunities for cross-border action between our region and potentially these European markets as well. So, it remains to be seen how tightly these laws are going to be defined and how well we will be able to work with our counterparts in different parts of the world in order to really leverage these legal frameworks. And, we recently celebrated the 10th anniversary of the UN Guiding Principles on Business and Human Rights. So, the UN Guiding Principles are really the authoritative global normative framework for responsible business. And they created an expectation for businesses to exercise human rights due diligence to identify, prevent, and mitigate adverse human rights impacts. I think for the next decade, a real theme that is emerging and will continue to emerge is access to effective remedy. And it is very clear that there are significant barriers to accessing judicial remedies. This is not to say that one must give up on the criminal justice system or going through the judicial pathways, but issues of fractured rule of law, corruption, asymmetries of power, lack of resources, criminal defamation, so many things continue to hamper access of the most vulnerable to judicial systems. In terms of non-judicial remedies, I think there is a very interesting opportunity at the moment to really focus on and build non-judicial remedies that would work as a complement to judicial remedies. And these have to necessarily take a multi-stakeholder approach. It's not good enough to have a company prescribe to workers a system, a grievance system that they have to use, which has not been designed with them in mind, which has not been designed with their voice, which has not been designed, with full consultation around their needs and what they would need to trust the system. Likewise, I think we are still some time away from having worker-led remediation efforts. But can we bridge the gap? And can we find a middle ground? I think we can. And as we enter this era of pandemics really bringing business to its knees, pandemics increasing vulnerabilities to such a degree, there is an important role for non-judicial mechanisms to play, and for non-judicial or quasi-judicial mechanisms that are dynamic, responsive, and innovative in the way that they harness workers' voice, they represent the needs of workers, and they reflect the design features that workers wish to see in a remediation mechanism, but at the same time that they actually look and fit into corporate governance processes, so that as the remediation happens, there is learning that is gathered from that process, which is then folded into the existing corporate governance processes. Because unless and until we are able to harness learning and put that learning into practice and make changes at the corporate governance levels, we are merely putting a Band-Aid and the problem will recur. So it is really important to have non-judicial mechanisms that will allow a more dynamic approach and that will help to complement the existence of judicial mechanisms, so that one can really leverage the due diligence requirements and so much other elements that are going on right now. So we've got the import bans that are putting pressure. We've got the modern slavery reporting requirements. We've got the strategic litigation efforts. But at the end of the day, on a day-to-day basis, there is a need for non-judicial mechanisms that really reflect and reconcile the needs of various stakeholders to actually exist, to be adapted to a specific context and to a specific sector and to specific stakeholders, in order for individuals to be able to access justice and remedy. Doesn't matter whether they're in an electronics factory or whether they are on a distant palm oil plantation somewhere. And just to wrap up, I'd really like to say that there are very hopeful steps towards global convergence. I can see the potential in legislation popping up in the sanctions approach and in the disclosure and accountability regimes in bringing together and in converging this idea of the corporate responsibility to respect, protect, and remedy human rights. There is a very important role for local and global cooperation to play in strategic litigation cases. The emergence of the laws are now of global application. And access to remedy, which remains a challenge for workers, remains something that really needs to be approached with innovation, but also with migrant workers at the heart of it, and bearing in mind the challenges of managing some of these solutions through corporate processes and making changes that are lasting and sustainable. I guess COVID-19 really highlighted the failings of the way these vulnerabilities crystallize so quickly. And the fact that suddenly overnight factories were closing, people were losing their livelihoods, their homes, they were becoming more vulnerable to exploitation. Their communities were affected, levels of poverty rose very highly. And there just wasn't any access to remedy. There has to be an effort, not just at local level, but at the brand level as well, suppliers are not single-handedly responsible for violating the rights of workers. Buyers have a very big role to play, and purchasing practices must change. Otherwise, we are not likely to see any sustainable change. So really, there has to be a ripple effect across the supply chain, which will involve every single actor across the board to give, to take, and to respect. And I guess, on a final, because remediation is the focus of what I do, I'm very hopeful that remediation frameworks that will be proactive, dynamic, and creative will really serve a purpose of bringing and reconciling a range of interests, agendas, and partnerships together. And that, you've heard in my presentation that there are many opportunities, there is momentum. The question is, how are we going to mobilize ourselves in order to leverage these opportunities? Because these opportunities are there for us to take. Thank you. I'll pause here and take some questions.
Whoa. Wow, amazing. I was like furiously writing and seeing connection points and opportunities for a much deeper collaboration for us, many of us as NGOs, and challenging us to broaden our horizon and how we can get involved in a lot of these non-judicial remedies. So, oh my gosh, I have a million questions, but anyway. First question that's come in. It's very important session that you've done on the legal framework. Please, can you give more details on the legal procedures of bonded labor? Oh, Archana, let me just unmute you. Yeah.
Sorry, after 2 years, you'd think I'd have got the hang of it by now.
Oh, I'm the same.
So it had to be a really difficult question to start with. I think, this whole issue around debt bondage itself is largely misunderstood. Debt bondage means something very specific under legal frameworks. And we often use the term very loosely. It's like using the term slavery to describe everything that's wrong, pretty much, in the world of exploitation. And debt bondage became something very symbolic in relation to that. And that also blurred the understanding of, what bonded labor is and, what the differences are, especially when you see the different forms of bonded labor across different sectors. For example, it looks a certain way on tea plantations in India. It looks a different way in brick kilns, but fundamentally it's the same concept and the same idea of creating this element of coercion that keeps an individual and future generations of that individual's family and community stuck in a situation that they can't step out of. And I think, when it comes to bonded labor in particular, there are such strong often cultural and social subtexts that are attached to it. For example, the caste system in India and how that plays into the whole scene, that it's not simply a question of going in, enforcing, and then just putting an end to it. It's a question of achieving a change in the mindset and, really shifting the way people perceive the value of this work and the people who are undertaking the work, and the relationship between those who are essentially commanding the work and those who are doing the work. So, from the perspective of legal procedures, I mean, it's really, really important that we use the opportunities that become available under the transparency and disclosure regimes to highlight where the hotspots are, what are the sectors affected. We're now starting to see people like Tesco, for example, publish the entire list of suppliers, including every single tea plantation from which tea is bought, which is sold in Tesco. The second stage is really to do some supply chain research and to identify some of the actionable points. So where is it that, there are clear nexuses with international markets where leverage can be applied? If it's the UK, can we use the UK Modern Slavery Act to apply pressure on a company to really look at addressing bonded labor? But again, this is a problem that has existed for decades, and it's a problem that requires a multifaceted and a multi-layered approach, rather than something which can be addressed by just enforcement. So really a sort of a panacea of legal action, and ownership of issues, and looking at it from an anthropological perspective, and looking at how one could achieve that sort of change in the mindset, in the way people perceive this labor. And I think giving economic value to the labor and giving an economic voice to those who are conducting the work and their own identity is really important, and something that is often not done. And you can see a lot of these nuances also in the informal sector, where you have, for example, domestic workers who remain largely invisible in people's homes, where there is no recognition of them as economic actors, or as, those who are participating in submitting, close billions of dollars of remittances to their countries of origin, and bringing great value to the country of destination too.
Amazing, thank you. Just waiting for some others to come in, so I'm just going to jump in, Archana, as I do. So a little earlier you were talking about, from the local to the global, and the Freedom Fund report. And I'm really interested in your comment about that there not being enough engagement between NGOs. I'm going to go with this, right? Not enough engagement between NGOs in the global south and the global north, needing global referral networks. What can that look like? How, I'm thinking of the global learning community. How can we bridge some of those gaps and be a part of some of this process in connecting NGOs? But also the second piece is, how can we be a part of this non-judicial access to remedies? What does that look like for the NGO practitioners on this call? So those kind of two pieces.
Yeah, I mean, the first piece really, what can be done? I think a lot of the NGOs who work in this space are very under-resourced. Many organizations have just one lawyer, if at all, and they may rely on external lawyers to do pro bono work to help them. They have caseworkers. You're very familiar with a lot of these struggles with resources. Now, in order to build and manage and nurture relationships with counterparts who are in another part of the world and have their own challenges in another part of the world, is actually very time consuming and resource intensive. So what we found was, through the work that I did at Liberty Shared, having a connector in between that manages, nurtures, builds the relationship, and brings the parties to work together closely, and that actively nurtures the relationship, helps to build trust. And that connector must be someone who's based in the region, because it only works if they're visible. There's someone you can pick up the phone to. There's someone you can speak to face to face. And you can keep working on the relationship both in Asia, and you continue to work with the counterparts in Europe. It takes away the pain of nurturing and building that relationship. And then as the first one or two cases start to happen, there is trust building as that's going on. And the trust building exercise is slow. I mean, some of the concerns we heard from counterparts who were interviewed as part of that research in the region said that, they were scared of handing over their work. They were scared of handing over the information relating to clients. They were like, what if it puts the clients at risk? What if others just take our stuff and just run away with it? There were real issues of trust around appropriation of work. And I have to say that this is not entirely unjustified, because in actual fact, when the Palermo Protocol celebrations took place, you just really had to look at the panels that were put together, the representation of Southeast Asia was very, very, very disappointing.
Ah, okay.
So, there is a real need for our region to have its own agency, its own voice. That's why today in the presentation, I emphasize some of the fantastic work that is being done in the region. It is possible to do it. We need to scale it up and we need to learn from each other. But at the same time, in order to do a better job at changing and pushing the barriers, we also need to be networking with Global North NGOs because they're doing things, using frameworks that we are not familiar with. And we would like to be able to benefit from that too, because a lot of these companies are operating on our doorstep.
Yeah.
So I think having a connector really helps because it takes the sting out of building, identifying the right people, and then constantly putting time into managing the relationship. It's not enough for Global North NGOs to come and do a couple of outreach sessions and then to just leave and expect case referrals. It doesn't happen that way. So that's part one. Part two, the remedial mechanism. So one of the things that we've been working on at the Remedy Project is we've designed a remediation mechanism that brings together co-creation efforts by workers and by companies. So the design features are very heavily influenced by what workers say they want to see and what would a system that they would trust look like. Now, the beauty of a framework like this is that there is a very significant role for every single stakeholder to play across the board. So the CSOs have a very important role to play within the management and within the representation of workers and their issues and their knowledge of the local context, etc. Trade unions have a very important role to play, in relation to the promotion of rights. The corporates, the industry bodies, the buyers have a role to play because they're all involved in this effort, whether they like it or not. And, you have legal advisors who are there to provide independent legal advice to migrant workers, etc. So, there is something for everyone to do because in reality, it takes a whole community to look at this issue and to find a solution. Nobody is going to go at this alone. And that's the reason why we don't find the solutions we need to find because we still haven't found a way to work together.
Yeah. Fabulous. Well, count me in, Archana. Whatever we can do, either on the ground in Cambodia or here in the UK, through the global learning community or through Chabdai. Yeah, my hat's in the ring, count us in.
Thank you.
Okay, so we've got about 10 more minutes. Does anybody, if you want to just unmute yourself and ask some questions?
Or even make a comment or an observation. Perhaps someone has done something interesting they'd like to share. I'd love to hear from them. Unless I put you all to sleep, that's also a possibility.
Oh, no.
I'll be brave. Good morning. Sorry, I was yawning because I was up late with my child, not because you put me to sleep. Thank you so much for an incredible, very rich presentation. I'll probably be listening to it again. I wanted to just, it's not a fully formed question, unfortunately, but I'm doing work in the Middle East where we're just, like you were saying about the presence of, the domestic workers and just the lack of really acknowledging, the economic capacity that these individuals do for their home countries, and obviously the labor that is being put forth in the Middle East. And we're at very, immediate need kind of work in terms of helping people repatriate and helping organizations provide good services for when those folks go home. But if there's ever a question around what can be done from an advocacy perspective about finding some sorts of legal justice, I use that term very, very loosely because I know those words mean a lot for a lot of different people. But if you have any comment on specifically domestic workers and in the Middle East, I would appreciate that if you can make sense out of my ramblings.
Yeah, no, sure. And So here's the thing. I think there is a lot of ownership that needs to take place from the sending countries. There must not be bilateral agreements to send migrant workers unless there is a mechanism built into it and protections built into it that are of a higher standard than the country they're being sent to. If the country that they're being sent to does not acknowledge or respect the fact that these individuals are workers, which often happens. So domestic workers are often invisible in employment legislation in many countries. And therefore, that means they fall outside of the purview of the law. It is the responsibility of the sending country to ensure that these standards to a higher level and mechanisms to resolve these are actually built into the bilateral. The second thing that needs to happen is workers must not be sent to locations where there is no in-country presence or consulate or labor attaché who is able to provide immediate support and relief. I think the Philippines do this very well. They're very active in terms of, who their labor attachés are, how they engage with local populations, the type of advice they give, the way they readily reach out into communities of NGOs to get legal representation and support and protection for the individuals that come from their country is really important. There needs to be at least this degree, because with some countries in the Middle East, the advocacy efforts are going to be very limited. The legal frameworks are severely deficient. But if the sending countries band together, and that's the other thing, if we get a degree of multilateral sort of, banding together in the sending countries, together they can use the leverage, because the Middle East will always need domestic helpers. And if suddenly the supply of it becomes, a lot harder, then that'll be a very interesting proposition. But then again, the question of economic need and economic greed always steps in, and multilateralism kind of, fades into the background given that. And sadly, it becomes a race to the bottom, like who can send the cheapest labor and who can do it as quick as possible. And that's where you see the maximum exploitation. But I think there needs to be a lot more of a stronger narrative around the economic value and the participation of domestic workers globally.
Thank you. I appreciate that.
Yeah, I'm really grateful for what you just said there, especially around the economic value of domestic workers and their invisibility globally. So we have a question here, and I know that you're on the call, but so maybe you can expand on this. But it says, as an NGO, how can we help provide legal support to victims? I'm not quite sure whether you're referring to finding pro bono lawyers, or whether you can make sense of that, Archana.
Yeah, so here's the thing, right? If you want to provide legal support and you want to be really ethical and have integrity in the way you do it, don't provide support that you're not qualified to provide. Because the problem is that if you rely on anecdotal evidence of so-and-so did this and it worked for them, and you then counsel somebody who's in a very vulnerable situation to go and do something which then backfires on them, it's not a good place to be. So if you don't have legal capacity within your organization, or you don't have caseworkers who are trained to understand and use the law, then perhaps it's not the best idea to be providing that legal support yourselves, unless you build the capacity to do it. What you can do is to identify other actors who you can contact and liaise with on behalf of the individual in order to ensure that they are able to access support. Another thing you can do is, if you do want to build your legal capacity, perhaps identify some pro bono actors who might be willing to work with you to provide that kind of support to the individuals that you work with. But as NGOs, we must really be aspiring to high standards ourselves, and we must be very careful about not falling into the trap of wanting to do good, but actually causing unintended harm while trying to do good.
Yeah, thank you. And I'll just kind of share just 1 minute on our journey as an organization. So we are an NGO in Cambodia and providing support to the survivors that we're working with. We ended up using pro bono lawyers for a number of years while we built our own frameworks and capacities and took on our own lawyer. But actually, we still do a mix of both. So we have our own lawyer and soon to be two, but we also do use some pro bono lawyers as well for the less complex cases. One of the things that we did realize with using pro bono lawyers is that they have their own workload as well. And often if they had a complex case for us, they just weren't able to dedicate the number of hours that it needed. And sometimes our teams would get to court and there would be 2 defense lawyers and our pro bono lawyer. And so there was, very, very hard for us to get a helpful outcome on that. Okay. I know that Archana needs to leave in just a moment. Did you want to say anything final, Archana, before I finish off our session?
Yeah, I mean, I've been in this space for some time now. It's been 15 years or 15 odd years. I think I've stopped counting after 15 of doing this work. It's been a privilege to work with some of the most fantastic human rights advocates globally, including, yourself, Helen. And there has been so much learning to do. And I guess, we all have so much to give. And I'll reinforce the message I gave at the last ARAT conference. We really must find better ways to use what we have within our arsenal. That includes the manpower that we have between us. And it also involves leaving behind divided agendas. There are no divided agendas here. We're all driving towards, the same goal. With remediation, what I have really relished about doing this work, in particular at this stage in my career, is that it's all about reconciliation. It's about compromise. It's about bringing together solutions in a progressive way. And it's about accommodating people's needs and building trust. And without that, we are nothing as a movement. So, I'll leave it there.
Yeah. Fabulous. Thank you so much, Archana. It's been a delight and pleasure and makes me want to make sure that we have one of our catch-ups again soon.
Absolutely.
And thank you everybody for joining this amazing session, which is the last in our ARAT conference this year. So thank you for joining. You can listen to all of these sessions again afterwards and spread the word, because we need as much manpower around the table as we can. So have a great rest of your day, everybody, and thank you for joining us.
Thank you. Bye-bye.
Thanks. Bye.